Okay, ladies and gentlemen, if we can call the meeting to order, and welcome to the Police Service Board meeting for October 2018. I apologize for the half-hour delay, but other business detained us. Let me start, if I may, with the land acknowledgement. We acknowledge the land that we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat peoples, and is now the home of many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Let me start, colleagues, by asking if there are any declarations of interest under the Municipal Conflict of Interest Act. Hearing none, thank you. May I ask for a confirmation of the minutes of the meeting held on September 28th, 2018? Councillor Hart, seconded. Ms. Chandra-Casera, all in favor? Any contrary? Thank you. We'll go through the agenda items. There are no presentations this month. Item number 2, there's deputations, so we will hold. The same is true of item number 3. Item number 4 is the special funds request for the LGBTQ conference hosted by Toronto Police. Motion to approve. Councillor Hart, Ms. Chandra-Casera, all in favor? Any contrary? Carried. Item number 5 is a deputation. Item number 6 over the page is the Toronto Action Plan to confront anti-black racism. Motion to approve. Councillor Hart, second, Ms. Chandra-Casera, all in favor? Any contrary? Carried. Item number 7 is the independent civilian review of missing persons investigations. It's the account payable. Motion to approve. Ms. Chandra-Casera, Mr. Jeffers, all in favor? Any contrary? It's carried. Item number 8, there we will hold because there is a motion to it. Item number 9 is the Chief's Administrative Review into the sexual assault complainant number 2018H. Motion to receive. Councillor Hart, seconded. Councillor Nunziata, all in favor? Any contrary? Item number 10 is the Chief's Administrative Investigation into the vehicle injury to Mr. Zain. A motion to receive. Councillor Hart, Mr. Jeffers, all in favor? Any contrary? That's carried. Thank you. Item number 11 is the Chief's Administrative Investigation into the vehicle death of Mr. Todd Feairs. Motion to receive. Mr. Jeffers, seconded. Councillor Nunziata, all in favor? Any contrary? It's carried. Thank you. Item number 12, another Chief's Administrative Investigation of the custody injury to Mr. Michael Dela-Cruz. A motion to receive. Councillor Hart, Councillor Nunziata, all in favor? Any contrary? Thank you. Item number 13, Chief's Administrative Investigation of the custody injury to Mr. Ronald Markel. Motion to receive. Councillor Hart, seconded. Councillor Nunziata, all in favor? Any contrary? Thank you. Item number 14, final Chief's Administration investigation into the custody injury to Mr. Christopher Fleet. Motion to receive. Councillor Hart, Ms. Chandra-Casera, all in favor? Any contrary? Thank you. And item number 15, there's a deputation to it as well. So the first item held is the occupational health and safety implication and occupational health and safety implications in relation to the legalization of cannabis. And there are 3 deputations, is that right? And the first is Derek Moran. Derek, you have 5 minutes, and I'll give you a 1-minute warning. And just wait till I set the time. Okay, there you go.
Be in any way my consent expressed or implied in doing so is fraud. God bless Her Majesty the Queen and long live Her Majesty the Queen. So in this report it says, it is the service's position that it is reasonable to have an approach that fits the Toronto environment and the expectations that Torontonians have of service members in the performance of their duties. Of course, considering, as I understand it, even though cannabis is legal now, though one can still be busted for what's termed illicit cannabis, I'm not quite sure what that means, if they don't understand what Section 32.1 of the Constitution means and/or that the Crown is the surety for the person we all have, then it's reasonable to also expect that Torontonians are aware of just what some of those duties that a police officer owes to us, because, you know, the duties are owed to people. So I just want to go over Police Services Act, Section 42.3, powers and duties of common law constable. A police officer has the powers and duties ascribed to a constable at common law, because this is not the common law Cannabis Act. There's the common law, and then over here, there's acts and statutes. They're two separate jurisdictions. And I just want to go over an email I got about 6 years ago from then MPP Mike Cole's office. Hello, Derek. I've been in touch with the Attorney General's office with regards to your question. The answer is that Ontario does not have a civil code like Quebec. We have rules of civil procedure, but they deal with procedural matters only, not the substantive law. Ontario is a common law jurisdiction, and we rely on the common law, not a code. Please feel free to contact us if you have more questions in the future. Regards, Joshua Luckhurst, Legislative Assistant, Office of MPP Mike Cole. I just want to point out, because there's lots of like the legality about smoking pot now. I just want to point out it's always been lawful for us to fire up a big fatty. Now it's legal, however, under the Cannabis Act, ultimately, for government employees to be able to smoke up, which is like, great for them. I'm happy for them. I just want to go over, Ken's laughing a bit here. I just want to go over, again, regarding your duties. Police officer, the oath that a police officer takes. The oath or affirmation of office to be taken by a police officer, special constable, or First Nations constable shall be in one of the following forms set out in the English or French version of this section. I solemnly swear, affirm, that I will be loyal to Her Majesty the Queen and to Canada, and that I will uphold the Constitution of Canada, and that I will, to the best of my ability, preserve the peace, prevent offenses, and discharge my other duties as, insert name of office, faithfully, impartially, and according to law, so help me God. Or, I solemnly swear, affirm, that I will be loyal to Canada, and that I will uphold the Constitution of Canada, and that I will, to the best of my ability, preserve the peace, prevent offenses, and discharge my other duties as, insert name of office, faithfully, impartially, and according to law, so help me God. So again, Section 52.1 of the Constitution is the supreme law, but the courts have also said that the Charter of the Constitution only applies to government action. And then Section 32.1, as I've gone over before, I think before, you're gonna have to spend some of our money at some point to invite Peter Hogg to come here and explain to everyone his clarification of 32.1, that acts and statutes only apply to government actors, government actions, or those performing a public function of government. Because I just mentioned Canada in that oath that a police officer takes, I just want to mention regarding the authority of Parliament in relation to the Upper House 1980, Supreme Court of Canada said, surprisingly, the word Canada in Section 91.1 of the BNA Act does not refer to Canada as a geographical unit. In our opinion, the word Canada, as used in Section 91.1, does not refer to Canada as a geographical unit, but refers to the juristic federal unit. The word Canada is used with reference to the juristic federal unit in several sections of the Act, of which the following are examples. This is from R versus Dom, 1996, Court of Appeal of Ontario. The Charter applies directly to government action, Section 32.1, and any government action is of no force and effect to the extent that it is inconsistent with the Constitution, Constitution Act 1982, Section 52. Legislative enactment which is unconstitutional is akin to a judicial order made without jurisdiction. Both are made without authority. Just as an accused can challenge the jurisdiction of the court to make the order the accused is alleged to have breached, that accused can also challenge the legislature's constitutional jurisdiction to enact the law the accused is alleged to have
Derek,
breached.
thank you. Appreciate it. Colleagues, any questions for Derek? Derek, thanks.
Legal, lawful.
The next is Chris Langenfeld. Chris, you know the rules.
I do, thank you.
Thanks.
I just had, when they first announced this, I had certain issues with the chief having come up with the regulations without it having gone through the board. I understand that certainly as a short-term stopgap measurement, that's fine. But I'm glad to hear that from this, the board will actually be taking this up and getting some public input with regards to what the regulations should be. I have a little bit of concern just with, I certainly believe that we should hold police officers to a higher standard, but I don't think that should be a different standard. So if marijuana, it is legal now in Canada, so unless there are some studies that actually find and support the argument that having zero trace of THC in your bloodstream is anything more than that is detrimental to the operation or the function of policing, then I'm concerned about arbitrary regulations that say, well, you must have zero amount in your blood when without some proof that that is in fact limiting to the function of policing. We all know that, for example, consuming alcohol when operating a vehicle, you can blow 0.01 and that's not considered an offense, despite the fact that you have some amount in your bloodstream. That's not the case for somebody who's a professional driver like me. I have to blow 0.0 at all times if I'm driving. And so there are situations where different standards are required. That may come into play in the long term with cannabis use as well. But currently I don't know of any different standard applied there for people driving commercial vehicles or things like that. So I just have some concerns with us setting a different standard for police officers without at least some solid background and studies. There are certainly lots of studies going back to the 1950s that say marijuana caused anything you can imagine, from murderous rampages and psychotic breakdowns. So the fact that there might be one study that says it is dangerous, I think we need certainly much better information and proof of background evidence to demonstrate that it is a concern for police officers before we put them to a different standard.
Chris, thanks very much. Colleagues, any questions for Chris? Chris, thanks.
Thanks.
Brenda?
Yes. Thank you for moving that out of the way. Unfortunately, we only get 5 minutes to speak, and I don't want to waste my 5 minutes comparing tobacco to marijuana. But I can tell you that marijuana is dangerous. Marijuana smoke is dangerous. Tobacco smoke was originally conceived to be harmless, and I was the first person in Toronto in Ontario before the Grievance Settlement Board to say it was not. And I was denounced as being mentally ill by my union and the government at the time. And later on, when it was obvious to everyone and a law was passed about secondhand smoke, I did not receive an apology. So it is true that years can go by before there are studies that will back up what is being said. However, we are talking about the police force, and I want to spend my 5 minutes on marijuana. I think I have something important to say, but whether I do or not, I want my name to be attached to what I am going to say, because I think that I'm right. If I didn't, I wouldn't have said it. This will be one of the only times that I probably completely support the Chief of Police for protecting the public in an unusual situation. So this is what I would like to say to all of you. I believe that Toronto is already down on her knees, and I told you that last time we were here. This declaration of a sanctuary city, the gangs, the guns, the shootings, the stabbings, the murders, the illegal immigrants, the drug overdoses, and now legal marijuana. So our Prime Minister, I believe, has created a crisis in our police force by declaring that marijuana is harmless and it's now legal. And the reason he says he's doing it is because he wants to put criminals out of business. I don't believe any criminals are going to be out of business. I believe they'll just find new business like they did with tobacco. So what did they do? They gave their tobacco to kids and teens. Now, I am concerned that we are being distracted seriously from law and order by the legalization of marijuana and what exactly the rights of the police are to indulge in the use of marijuana, because marijuana is now legal. So is it fair to ask a group of people to give up their legal rights for the rest of us? And I say yes, in this case. I believe it's proper. I don't believe that the police should gamble with their own safety. I don't believe they should gamble with our safety. For example, the January 28 incident regarding 2 police officers from 13 Division who had supposedly ingested edible marijuana had the potential for a total disaster. They were both hallucinating, they had weapons with them, and if they had decided to use their weapons to fight off their enemies that they imagined were around them, then a number of people could have been killed or worse. God knows what, they could have gone on a rampage. One was up a tree and the other one thought she'd been kidnapped. These are serious matters, and I believe the Chief of Police is taking this seriously while other people are laughing it off. It is very serious. He's right. It is beyond serious. These people have guns, bats, pepper spray, tasers. So the police have always said they're special, and now they'll have to be special. They've talked the talk, and now they should walk the walk. In exchange for their privileged position in society, in exchange for their free education, $100,000 a year, their all-inclusive benefits package, Beyond the Blue Club with no fees, perks from the public, free lawyer if they get into trouble, you are now being asked, police officers, in a roundabout way to abstain from the use of marijuana, and you're expected to comply out of respect for yourself and others. For the good of yourself and others, for your families, for the public, to do otherwise would be to court tragedy. So my position, so that I'm clear, my position is there should be absolutely no question, never mind the 28 days, there should be no use of marijuana. They are role models of society. The police are role models of society, and they should not be seen to be engaging in this. We don't allow them to walk around drunk. We don't allow them to use heroin. But now we've got legal marijuana. So it's going to have to be up to them and their character to say, I'm not going to do this. Never mind what the chief said. Never mind what Mike McCormick said. Never mind what some doctor said. I'm not getting involved in this, and I'm going to continue to carry out my duty as a police officer. Thank you.
Thank you, Brenda. Any questions, colleagues, for Brenda? Brenda, thanks very much.
Thank you very much.
Colleagues, any discussion, debate, questions of the chief on the report? Councillor Hart?
Thank you, Chair. Just a follow-up question from Ms. Ross's deputation, actually. Going to page 3 of the report, Chief, it talks about the working group said that zero tolerance was unreasonable, and yet you landed on 28 days. Can you explain, in conjunction with some of the deputant's comments, how you landed on 28 days?
Well, the review that we've had has lasted over a year with respect to this very issue, knowing that it was going to become a point of discussion. And within that review, there have been presentations from our researchers which talk about THC remaining in the body up to different, depending on body fat, metabolism, and amount of usage, but up to 28 days. And when you look in the Health Canada website, it speaks to alcohol is not to be compared with cannabis. It has a longer half-life and can stay in the body longer. the fact that the organization, the Toronto Police Service, works in a safety-sensitive occupation, and decisions have to be made involving life or death in microseconds. Anything that may impede on that decision-making can compromise the safety of the officers, can compromise the safety of the public. When I issued the intern procedure, I did it openly, and I wasn't firm. I said, look, here's where the stance is. We're going to set the high watermark, open it for discussion so that others to the table, the association, the senior officers organization, working with the board, can figure this out, and we can work collectively together. Zero tolerance means you can't do it anytime, anywhere, ever. The airline industry has set that precedent. Other agencies have. Our watermark is lower than ground crews of certain airlines. So the 28 days, it provides opportunities for people that are on leave of absence, people that are on maternity leave, people that are on paternity leave. Some of our officers have up to 7-8 weeks off on holidays. They have the opportunity if that is the case. Once you walk into the door to work with the Toronto Police Service at this point in time until science or if there's a discussion that alters that, I created a high watermark because I thought that was necessary due to what we're asking the men and women to do each and every day in the City of Toronto.
Okay, Jim, Ugla, and then Ken, and then Francis.
Thank you. I think we all agree that this is a really challenging discussion and challenging topic, and every industry kind of has to set their standard. And the science isn't exact, right? And there's no doubt more research is needed in this area, but what we do know is that cannabis is not a benign substance, right? So I was really happy to see that there's a working group that you're taking advice from, and that this is an interim process. I think my comments and my advice to you is really when you're considering fitness for duty, really thinking about not just fitness for one substance, but all substances, right? Because fitness for duty is fitness for duty, regardless of the substance that's being used. And then ensuring that there's a separate policy for those who use it for medical purposes, and having accommodation policy. And then, of course, ensuring that a variety of healthcare providers are consulted. I think you mentioned Health Canada, that's great, but also the Ministry of Health, and then Toronto Public Health, which is right in your backyard. I think getting a really wide perspective on this as you move forward with your new policy, I think would be great.
Ken?
Yes, sir. Question for the chief. I mean, I think we all agree this is a real challenge in terms of determining impairment and being fit for duty. Do we have in place some ways of determining the level, the differentiation between impairment and being fit for duty, and what would we do to determine that?
Well, I can say that the discussion on fit for duty is a live discussion, and a discussion that I certainly invite all parties to participate in so that we can find that particular benchmark. I think prior to this, the fit for duty had a stronger lean towards alcohol consumption when we're talking about recreational drugs. One of the board members spoke on different drugs, but I'm sticking with the recreational piece right now. And now that we've added another entity, which is that of cannabis, I think that it does warrant the discussion to have a look at the definition of fit for duty. Since the one thing that research says that is consistent is that you do not compare alcohol to cannabis. They are two different psychoactive drugs, and with that, I think that it's an opportunity to have a harder look at what fit for duty can be defined as.
Okay, Ken? Francis, you had a...
So you mentioned you look for signs. Now, what sort of signs? Like how can you tell?
Well, the science dealing with the working groups, the fact that we have hired people that have a better understanding of this discussion, and also utilizing our folks from labor and legal and a host of other people from my aspect of it, looking at other major cities to look at what their drug policies may be as well, scrutinizing that, working through to see what the legal ramifications are, and factoring all of those things to come with what is best Toronto-centric. I don't think that there is a one-size-fits-all. I think that the Toronto Police Service has to deal with numerously more points of contact where life or death situations are posed to them, dealing with being the fourth largest city in North America. And so that poses, I think, different challenges and a lot more opportunities for certain decisions that have to be made where hopefully everybody is fully cognizant and do not have any obstacles that can reduce or diminish the opportunity to make those microsecond decisions.
Ken, you have a second question?
Yeah, just maybe a follow-up to my earlier question, and that is maybe directed to legal counsel. In terms of one's, in terms of one's legal rights, would it be intrusive to examine, you know, a member of the force, a police officer, for example, in determining when and how they may be impaired or not fit for duty? What rights do they have in terms of dealing with that? Legal rights.
So, Mark, I think that was more directed to you and your legal counsel. It's your report.
Well, I'll take a poke at it, and then if there needs to be further expansion. I mean, fit for duty is broad in a sense. However, it's based on an individual encounter. When officers are paraded for duty, a supervisor looks to make sure that they have all the necessary equipment to perform the duties, and as well to see and challenge whether or not they're fit for duty. There have been cases where the smell of alcohol, slurred breath, glossy eyes, that type of thing, it's easy to say that that person would be unfit for duty. Every officer has an opportunity, if they're challenged on being unfit for duty, to challenge that. And there are mechanisms in play through the procedure that gives and provides that opportunity. But by law, police officers, law enforcement officers are allowed to make general opinions. And so if that general opinion is that that person is unfit for duty, depending on the magnitude of the signs that display that, it can dictate whether you can further act upon that or deal with the opportunity for the person to challenge that.
Okay, colleagues, any other questions, debate, discussion? Chief, thank you very much. It's a complex and important subject, so thank you. Colleagues, with that then, may I have a motion to receive the depositions and to receive the Chief's report? Councillor Hart, seconded Councillor Nunziata. All in favor? Any contrary? Carried unanimously. Thank you. Item number 3 is the Chief's review of the historical data, second quarter of April to June 2018, and there is a deputy. Oh, and 3.1. I'm sorry. The also the access to historical data, second quarter from Chief Saunders. So there is one deputation, and that's Chris Langenfeld. Chris, thanks.
Hello again. Just real brief on this. I'm just wondering if there's any actual legal opinions that say that the service should maintain this information. I know that the argument has sort of gone the other way, that there have been questions, well, is there any legal opinion that says that it shouldn't be destroyed? And I understand from this report that you're waiting to hear back from Justice Tulloch on this. I don't remember seeing anywhere where it was disclosed that what question it was you were asking him. I'm assuming you're asking him if there's any reason that it shouldn't be destroyed, but I'm wondering if you currently have any opinions that say that that data should be kept at this point. I point out that when we see the regular reports on Freedom of Information Act disclosure, that the service is always well behind the required 30-day reporting periods. I think it's 50, you're around the 50% mark of meeting the 30-day timeline on that. And I would suggest that that's because of the amount of data that you're currently keeping on people, or that the service is keeping. And so if we can reduce the amount of data that police are keeping on individuals, if it's not warranted to maintain that information, for example, carding information, then that should speed the ability to respond to those requests and should reduce the workload for the service to deal with Freedom of Information Act's requests. So I'm just wondering if you have any other opinions.
Okay. Okay, thanks. Colleagues, any questions for Chris? Chris, thank you.
Thank you.
Colleagues, any discussion on this issue? It was one that at the time we brought it out in the discussion of carding and the original discussion around retention of data. It did get very broad discussion in the public in this forum, and this is a continuation on of it. It was the control mechanism put in place to make sure that there was not that there was only essential access to data. The committee that was formed to look at it has met rigorously and asked the questions and had a great deal of input from the service. Progress has been made, but I think the committee has felt for some time now, and Audrey Campbell is here as one of the members, that the data is not does not appear to be essential, at least to date. There's a minimal number of requests. I think it's 3 last time. 1 was for operations. So the question comes, we recognize that Justice Tulloch's final report is coming down, I think, in January, and the public report will address that. So this is just the ongoing reporting from the committee that was established to make sure that the access to the data, the historical data, was monitored appropriately. Colleagues, if there are no other questions or no other discussion or debate, or Chief, I don't know if you wish to add anything, may we have a motion then to receive the deputation and to receive item number 3 and item number 3.1. Francis Nunziata, seconded Upala, Shanagusera, all in favor? Any contrary? Carried. Thank you. That takes us to number 5, which is the eJust Case Management System Maintenance Agreement, Sole Source Award. There is a deputation, and it is Derek Moran.
So because this item deals with disclosure a lot, full disclosure, Chair Pringle, we spoke briefly at the end of the last meeting, and you took quite a shine to when you heard about the rules at the Toronto Public Library Board, and you're thinking that was a great idea, letting people come here and only speak 5 minutes in total, no matter how many items they sign up for. So I just wanted to let you know, their procedures is 29C. Each presentation is limited to 5 minutes, excluding questions from board members. This time may be reduced or extended at the discretion of the chair. So that's each presentation is limited to 5 minutes each. There's no, oh, you only get 5 minutes in total for the whole meeting. So it seems the Toronto Public Library Board has just given themselves extra special magical authority powers to deviate from the policies consistent with every other City of Toronto related public meeting. I'm just saying that. I know it's off topic.
This is off topic. It's way off topic.
I know it's off topic, but I just want to make sure that you don't adopt the same.
Councillor Hart's looking in his book to see what you're talking about.
I just want to make sure you don't adopt the same corrupt policies at this board as they do at the Toronto Police Services Board. So in this item, it says, the eJust CMS application also supports interoperability among justice partners such as the Ministry of the Attorney General and other government agencies, for example, the Public Prosecution Service of Canada, that request disclosure packages from the service. Now, ironically, I had a disclosure package myself in my hands briefly this morning, and I just want to point out that I stapled to the front of it a notice of mistake here, and man, you should have seen the look on the lawyer's face when I handed it back to them. Whew. So Disclosure packages, they're very important in the job that the Ministry of the Attorney General and the Public Prosecution Service of Canada and that the police do in helping to attorn their fellow man or woman to the Crown as a ward of the court to the government. So disclosure is actually mentioned, I don't know if the police know this, on the Law Society's own website under the rules of professional conduct. Duty as prosecutor, I just want to read this out on the record, deals with disclosure. 5.1-3, when acting as a prosecutor, a lawyer shall act for the public and the administration of justice resolutely and honorably within the limits of the law while treating the tribunal with candor, fairness, courtesy, and respect. When engaged as a prosecutor, the lawyer's prime duty is not to seek to convict, but to see that justice is done through a fair trial on the merits. The prosecutor exercises a public function involving much discretion and power and must act fairly and dispassionately. The prosecutor should not do anything that might prevent the accused from being represented by counsel or communicating with counsel, and, to the extent required by law and accepted practice, should make timely disclosure to defense counsel or directly to an unrepresented, such as myself, accused of all relevant and known facts and witnesses, whether tending to show guilt or innocence. For example, the lawyers I spoke to this morning had no idea that the Crown is the surety for the person we all have. I couldn't believe it. I know. So this is from Black's Law Dictionary, 9th edition, just so everyone knows. Disclosure is defined as 1, the act or process of making known something that was previously unknown, a revelation of facts, see discovery. 2, the mandatory divulging of information to a litigation opponent according to procedural rules, also termed compulsory disclosure, automatic disclosure, see discovery. Full disclosure is defined as a complete revelation of all material facts. Material fact is defined as a fact that is significant or essential to the issue or matter at hand. And I didn't bring it up last month, but remember, is this guy's name Ryan? Because remember 2 months ago, Ryan said to me that we'll look up for the specific rule, and then you said, Chair Pringle, I will commit to come back to you on that. Did you guys ever find the rule in your rules that says that we can't ask questions at these meetings?
Yes.
Is it posted on the website?
Check the website.
Did you guys update it?
No, it's
No.
part of our procedural bylaw, and afterwards, if you want, through email, we can correspond with you and provide you further information.
Derek, your
Cool.
time is up. Thank you very much. Are there any questions, colleagues, for Derek? Okay. Thanks, Derek. With that, are there any questions or comments, colleagues, you have on the item before you? If not, a motion to approve this and receive the deposition. Francis Nunziata, seconded. Jim Hart, all in favor? Any contrary? It's carried. Thank you. Item number 8 is held for a motion, which... Oopla?
Thank you for this report. One thing that I noticed as I was going through it is we received a similar report. I believe that's the annual CEW usage back in April. And I just noticed a discrepancy between this report, and that report seemed to have a lot more detail in terms of the gender of the subject, age, especially any incidents involving youth, the incident type, behavior, subject behavior, and a description of whether the incident and whether the escalation techniques were used prior to displaying or using the CEW, and whether mental health apprehensions were made following the display or use of the CEW. So I think it's a little bit challenging to ask informed questions. We don't have that full picture, and hoping that you'll be able to provide us with that information in addition to what you provided, which is a great start.
Yeah, thank you. I can provide a reason for that. I think there was discussion at the February meeting, the amount of work that goes into the annual report and the analysis that this quarterly report, and within the motion, would look at the items on the top of page 2. And all that analysis that you're referencing would be within the annual report. To have all of that work done quarterly is a lot for my analyst. But I have some. I want to talk about some numbers. So I did anticipate that a couple of other numbers would be helpful for the board. So within that period, we're only looking at May 15 when the CEWs were actually on the street. So after we purchased, started to train, and then they're out in the street. So May 15 to August 14, 3 months. So within that time period, I know there's some numbers that are in the board report, but also in that time period, it's important to have some context, as I think what you're asking for. So we looked at number of calls for service, because I know that person in crisis are always some concern with the use of this tool. We handled over 8,100 calls for service for persons in crisis. The CEW was used on persons in crisis 52 times, so 52 persons, so that's less than 0.02% of the time. As well, we made over 6,500 arrests during that time. And so that's 66 other people where the CEW was used, again, less than 0.2% of the time. So with the added accountability, I'll say there's accountability within the tool itself, the ability to download when it's used. We've added some other accountabilities. We've increased the training. We've also increased or required of our members when they do use it, that they notify a supervisor, they notify TPOC, and that kicks in some of the immediate notifications that it has been used, so that analysts, supervisors, unit commanders can know that it is being used. So while I'm able to have that today, I wasn't able to have that for this report because it was written a month ago. But it does provide some context that we're looking at hard numbers, but there are some other important things going on. I can also tell you that the use of empty hand techniques in terms of use of force is going down. The use of the baton is down from the same period this year to last year. The use of OC spray down. So we anticipated, we call it a less injurious option, and we are seeing the other uses of force options, their use going down, which is important because if you remember when I was here in February, I mentioned that looking at 10 years of SIU data where a threshold injury has occurred, the most often circumstance were actually with empty hand techniques, and we're seeing all of that. Those numbers, although it's really only 3 months, those numbers are going in the right direction.
Thank you. I think that's very helpful. And the previous report that was provided, I thought was really excellent because you did have a lot of that information in it. And I appreciate that it's a lot more work to do that level of analysis. But I think considering that this is a new initiative, right, in that you're expanding the use of CEWs to PRU officers, I think especially at this moment in time, it's important for us to get that information kind of quarterly. And once it's becomes the regular practice, then I think perhaps we could at that point discuss going back to more annual look at the information in that way. But I think at this point in time it would be very valuable to have that analysis.
So I will endeavor to get it. I think the next quarterly is actually going to almost coincide, thank you, with the annual report. The timing of it, that we would start writing it, is actually the same timing for our annual report. So I may have some conversations to see if I can actually just combine them.
Now, will you have a motion you wish to put before colleagues?
Yeah, that's great.
Is it captured all accurately?
Yeah, and the number 2 there is a reference to There was discussion in February about doing a study with an external party, and the board allocated some funds to do that. And so I think that's a reference to that.
If you could just give me a minute to
Yes,
absorb this.
certainly.
It's quite lengthy. I want to be cautious with the board with respect to asks of other agencies and how they measure and what they measure, and the fact that, it's going to certainly have an effect on the timeline to get, I think, what your desired effect is. So I would ask that for the next period of time, we're given an opportunity for 1C to explore what we can capture from that and then present to the board on a sidebar so that we can get it right.
In light of that, do you want to pull C and
I think C actually might be covered if we look at what was requested in February, which was to do an international review of best practices regarding use of force options, including alternative CEWs and tactical approaches. So I feel like that would be covered in that request. So you could remove
take
this.
C out?
Yeah,
Okay.
you could take C out, yeah.
So colleagues, any discussion on, Chief, does that satisfy you?
Yes, it does.
And I'll just say with a caveat, if the other services do this type of analysis.
Colleagues, any further discussion? If not, you've got a motion on the table. If there's no other discussion, is there a seconder for the motion? Councillor Hart? All in favor? Any contrary? Carried. Thank you. And so with that is the motion to receive the chief's report as well. So that takes us now to which number? 15? 15?
15.
So 15, again, colleagues, is the two deputations, and it's the Chief's Administrative Investigation, the alleged sexual assault complainant 2018G, and the first deputation is Derek Moran.
This item deals a lot with centering around the Trespass to Property Act. And I just want to refresh Chief Saunders' memory that a while back I came here and I brought the police officer's manual and I read out onto the record what the police are told about what the rule of law is. Rule of law is a legal principle of general application sanctioned by the recognition of authorities that is usually expressed in the form of a maxim or logical proposition. It is called a rule because in doubtful or unforeseen cases, it is a guide or norm for a decision. Now, one of those maxims is, I believe the Latin is legis suum ligent latorum, which means laws should bind their own author. I've mentioned this before. The Legislation Act of Ontario, Section 6, says an act shall contain at the beginning the following words to indicate the authority by virtue of which it is passed, Her Majesty by and with the advice and consent of the Legislative Assembly of the Province of Ontario, and acts as follows. The problem with that is, as I mentioned before, the Trespass to Property Act does not have that enacting clause at the beginning of it. And as I mentioned earlier in R versus Dom, Court of Appeal for Ontario, any government action is of no force and effect to the extent that it is inconsistent with the Constitution, Constitution Act 1982, Section 52. So I don't, I know the police didn't write it this way. It's not their rules, but they're improperly applying the law when, whether it's Desmond Cole talking about DeFonte Miller here, whether it's me mentioning a librarian's name on Twitter, or what happened, I'm assuming this is a lady, because it would otherwise read something like Mr. Paul Doucette. So in this report, it says the officer then asked the person for identification and explained his authorities under the Trespass to Property Act, and the person refused to identify themselves. I just want to mention also there's another maxim of law that says equity will not permit a statute to be used as an instrument of fraud. I should have said that in the beginning. Like if the Trespass to Property Act is invalid and of no force or in effect to begin with, then that statute is being used as an instrument of fraud against people. So like this, the person here, the person there, I mentioned this before, like police officers should know the difference by now between the person we all have and people. If they don't, then they have no business being a police officer and being paid by the public to be on the street doing their jobs. So just to clarify this again, to make hit home the difference between the person and people, reference regarding the secession of Quebec, 1998, the Supreme Court of Canada said, "It is of course true that democracy expresses the sovereign will of the people. The Constitution is the expression of the sovereignty of the people of Canada. With little formal elaboration of the definition of peoples, the result has been that the precise meaning of the term people remains somewhat uncertain." This is Yikwo versus Hopkins, a very old case from the Supreme Court of US. Sovereignty itself remains with the people, by whom and for whom all government exists and acts. Halton Hills, Town of Halton Hills versus Kerouac, 2006. Superior Court of Justice. As long as ultimate sovereignty resides in the people, the state cannot be thought of having a separate personality and therefore cannot be said to have been defamed. So notice in these acts and statutes that there's no definition for person that says means people or person includes people. They're two different things. I tried to explain this to the lawyers at Old City Hall this morning. I don't know if they don't get it or they don't want to get it. But you said I had a minute left?
No, I had it for a while. You just looked up. You've got like 15 seconds.
15 seconds left. I just want to cordially, Chair Pringle, invite you, if you could pass along to Mayor Tory also, and even Chief Saunders, on Monday night to come see for yourself just how corrupt the Toronto Public Library Board is, because they're having their meeting on Monday.
Thank you, Derek.
And you're going to come?
No, thank you for your deputation.
And Councillor Hart's actually seems to be a good member.
I'm sure he is. He's good at everything. Colleagues, any questions of Derek? Derek, thank you.
People, person.
Chris?
Just before I begin, that's now the timer for Derek's 5 minutes going off. So you obviously need another watch, because I've been timing. You were 15 seconds off on the previous one and 30 seconds off on this time. So out of 5 minutes, when you're talking about that amount of time, that's a problem. So this issue relates to the Trespass to Property Act. So I brought you all actually copies so that you can refer to it. And as you'll see, Derek is quite correct that there is no enactment clause. But beyond that, you'll also find that there's nothing in there that allows for police to require people to identify themselves. And there's also, when you look in there, you'll find there's nothing in there about police or anybody else forcibly removing people from property, which has been an issue in the past in this building with large numbers of gangs of police officers dragging myself out. There is, of course, the authority in the direction that where somebody violates the Trespass to Property Act, they should be charged and arrested and taken to court. But of course, when you're enforcing unlawful acts, you don't want to go before a court. You want to just be able to rough people up in the streets and have them be done with it. I have some issues here with this case in particular. I notice, first of all, of course, the analysis doesn't actually reference any part of the claimed sexual assault. So there's nothing in the review here that says that there was any investigation of the claim of a sexual assault by the officer. But there's also an issue of where somebody's parked outside in a parking lot behind an apartment building. Could be somebody going to wait to pick up their boyfriend or girlfriend and sitting in their car waiting. And the argument that that means that if it happens to be TCHC housing, that they should expect police officers to come up and knock on their window and that they're going to have to identify themselves and explain what they're doing there. That isn't the way the law works, and that's not a requirement in a free society that we all have to answer to police officers whenever they come up and ask us a question. And this is a big issue that's coming into play here in Toronto, where more and more we have Toronto police enforcing rules on private property. And that is not the way our laws in a free society in Canada, North America, and the whole first and second world that are laid out. It's all based on the concept that private property owners have the option of having security or their staff question people when they have an issue that somebody doesn't answer. For example, special constables or TCHC security, if they were to go up and knock on somebody's window and ask them why they're there and the person refused to answer, they can then call police and have police deal with an actual claim of a violation of the act. But the idea that people are going to have to expect to have police officers come up to them and they have to explain themselves and answer questions, and if they don't, they're going to be subject to arrest or being pushed around and thrown out of buildings under the authority of the Trespass to Property Act, then that's an issue. And I invite you to show me anywhere in this act where it says that there is the authority for somebody to physically remove somebody from property under the Trespass to Property Act. There is no authority for that. There is a common law authority for pub owners to remove drunken people from their property, going back to the Middle Ages of England. But I don't think that translates to dragging people off of police property when they refuse to submit to a search, or dragging them out of their vehicle and demanding that they provide identification because a cop walked up and knocked on their window. So actually it's 1 minute 16 seconds. So, well, your timer is off. So this is an ongoing issue. This is certainly a concern here in this city, where we have more and more police acting to go out there and try and compel the public to explain to them why they're not breaking the law. And that's not the way our laws work. Our laws work on the basis of, if there's a complaint against somebody, police are then empowered and expected to investigate. And I think we're all fine with that. But that's very different from the imbalance in power that comes when you have a society that expects that any time with somebody with a gun and a badge walks up to you, you have to answer their questions. And of course, we know in reality that we're all entitled not to answer those questions. But if you're not actually obeying that section of the law, and if our only option then is to take the police to court, our courts are going to be even busier than they already are, and that's certainly a problem.
Thanks, Chris. Colleagues, any questions for Chris? Okay, thank you. Colleagues, any discussion or further discussion on this case, this item number 15? If not, motion to receive the deputations and to receive the report. Councillor Hart, seconded Mr. Jeffers. All in favor? Any contrary? Is there any other business, colleagues, that you wish to bring before the meeting? If not, a motion to adjourn. Councillor Nunziata, you almost didn't make first there, but and Mr. Jeffers, all in favor? Any contrary? Thank you.